Hi everyone, Massive Human Rights and Freedom Initiative welcomes you back to this afternoon of news, and indeed happy to inform everyone that Nnamdi Kanu, the leader of indigenous people of Biafra, has been discharged and acquitted. Then the people will be asking, what does it mean to be discharged and acquitted? And indeed, in a normal court and a normal process where there is no prejudice, where the government is not fighting a different war apart from the normal judicial process, discharged and acquitted is a language used by judicial experts and the judges, especially judges, when they discharge a case that has no merit, no evidence to prove that the victim or the prosecuted is guilty. In this, we will thank you and say good morning, good afternoon, and good evening to some of you. And also we use the opportunity to thank God Almighty, King of Glory, Jehovah Nisi, Jehovah Jireh, Jehovah El Shaddai, Chukwu Okike Abiama, Chukwu Okike Abiama of Igbo land, Chukwu Okike Abiama of Biafra land, Chukwu Okike Abiama of Eastern region, Chukwu Okike Abiama of Western region, Chukwu Okike Abiama of Northern region, Chukwu Okike Abiama of the entire Nigeria and the world. In this we say, today we are going to elaborate more on what it means to have a legal terminology called discharged and acquitted. Well, we look at various differences, but before we go on, we will say, please, we ask you to subscribe to this YouTube, share, give us a thumbnail, leave your comment. Again, we say, share these videos to your loved ones. And as we go, you continue sharing them, you listen, you share them, because the news may be the same, but there is a distinction on what Massive Human Rights and Freedom Initiative does when it is giving news. We give you meanings of the things that are related to the international human rights laws, to the laws of the land, and also to the laws as enunciated by the United Nations Human Rights Acts, which is a treaty, which is a covenant, which is a law accepted by more than 154 nations of the world, of which Nigeria is part of it, and they try to promote it only in the room of United Nations House Assembly and not in the country where they live. Nigeria is good inside Nigerian laws. Nigerian President Buhari is good inside international assemblies or United Nations Assembly room, but not in Nigerian soil. Then from there we will now continue. Before we get to distinguish between acquittal and discharge, what they mean, we will go back to the report of one of the Nigerian newspapers, Punch, of 13th October 2021, where it is stated, Court of Appeal, sitting in Abuja, the Federal Capital Territory, on Thursday upheld the appeal of the detained leader of the proscribed indigenous people of Biafra. That is, they are proscribed only in Nigeria. We will come to that. The court also discharged and acquitted the embattled leader of the proscribed group. According to the newspaper, Kanu had in his appeal dated April 29th and marked CA/ABJ/625/2022 applied to be discharged and acquitted. Kanu was first arraigned on December 23rd, 2015, and was later granted bail on April 25th, 5th, 2017, after 2 years of incarceration. Then, however, the Court of Appeal on Thursday declared as illegal and unlawful the abduction from Kenya to Nigeria and quashed the entire terrorism charges brought against him by the federal government. The Appeal Court, in a judgment by Justice Oludotun Adebola, voided and set aside the charges by the federal government against Kanu. The Appellate Court proceeded to discharge Kanu from the alleged offenses. Justice Adebola held that failure of Nigeria to follow due process by way of extradition was fatal to the charges against Kanu. Appeal Court further held that the failure of the federal government to disclose where and when the alleged offenses were committed was also fatal to the terrorism charges and made them liable to dismissal. The question many people are asking is, what is acquittal and discharge? What does it mean in a criminal case and legal term? Well, Massive Human Rights and Freedom Initiative has to explain this once again. In the last program where we stated what it means to have a reserved judgment and what that need to be, in this Massive Human Rights and Freedom Initiative explained critically what reserved judgment is. If you have not had opportunity of listening to that very explanation for your own personal use and knowledge, we ask you to go back to watch our video with headline Federal Government Case Against Nnamdi Kanu. Today we are going to differentiate between acquitted and discharged. For the purpose of acquitted, acquittal is a verdict in the criminal case that the accused is not found guilty of the offenses alleged against him, while the discharge is an order given by the Court of Appeal that there are no enough grounds during the proceedings, the evidence before them, that the accused has no case to answer. As a result, the case is discharged. Discharge of the accused or the victim of the prosecution is evidence that the case has no merit and that the court has viewed it, examined it, all the evidences, using all the details before him, implying the rules of the land, of the constitution of the country, and also the international covenants available to it, that the country of which, referring to Nnamdi Kanu's case now, that Nigeria signed all those covenants, it flawed during his kidnapping and rendition of Mazi Nnamdi Kanu from Kenya back to Nigeria. Kanu's case is more or less international case, as long as the International Human Rights Committee Against Torture examined the case and the reasons and how he was renditioned from Kenya back to Nigeria, and the process of trial, which is more or less a case of prejudicial case and not of the direct criminal case. In this situation, we will give a little light on what it means, again, acquittal and discharge. Like we stated earlier, acquittal means legally freeing the accused and declaring him innocent of the charges made by the prosecutors. The prosecutors here is Federal Government of Nigeria and those who are sponsoring them. Why the discharge which was pronounced in this judgment means that a legal order of release has been given by the judges who examined the case and came out to give a written verdict on this very criminal case, that the person is to be discharged and acquitted and free from the case of the government as long as the evidence before them has not been proved and nothing found in the evidence of Federal Government of Nigeria against Nnamdi Kanu. Therefore, the acquitted person cannot be rearrested on any ground of which the case has been dismissed. Since the Court of Appeal has realized and understood that all the charges against him were framed, therefore, after their judicial inquiry, decided that the accused be released, and this was pronounced by Justice Adebola, of which the Justice Hanatu was also one of the judges that examined the case. You should remember that it was Justice Hanatu that was in charge of the case, of which Binta Nyako of the Federal High Court has therefore been found to have erred in law by allowing the federal government, the prosecutors, to get the framed allegations which he could not herself discharge, but allowed the federal government to continue. As a result, the leading team of the defense counsel, that is Nnamdi Kanu's counsel, Barrister Ozekhome Mike, SAN, decided to make the formal appeal against the remaining 7 charges that were left behind by Justice Binta Nyako. As a result, everything has ended with the victory for the legal team and Nnamdi Kanu. Now we have to look at the interview of Nnamdi Kanu's international lawyer, Attorney Bruce Fein, interview with reporters or Sahara reporters. Let us see what he has to say.
Dimension that involved a litany of human rights violations. Bruce Fein, how will you describe Mazi Nnamdi Kanu's trial by the Nigerian government?
Before I give a one-word description, let me give a little bit of background for the audience so they can make their own evaluation rather than just based upon my opinion. Last June, while Nnamdi was visiting Kenya, he was kidnapped, tortured for many days, and subject to what's called extraordinary rendition to Abuja. We don't know all of the details because the federal government has been very reticent to disclose exactly what was done in collusion with the Kenyan authorities or with Kenyan bandits, if you will. to kidnap and torture and extraordinarily rendition Nnamdi to Abuja. But whatever the details, it surely did not comply with international law requirements for extradition, which entitles a detainee to notice an opportunity to challenge the legality of any kind of detention and prosecution, which clearly did not happen in this case. This was last June, so approaching now 6 months. Now, since that initial arrest and charges, there has not been a crumb of evidence introduced to substantiate any of the alleged so-called terrorism-relating charges against Nnamdi Kanu. The vast majority relate to broadcasts from London in UK on Radio Biafra. They were not broadcast from Nigeria. And the Nigerian Federal Criminal Code is relatively clear that for alleged crimes that occur outside of Nigeria, there's no jurisdiction to adjudicate those crimes in Nigeria itself, among other things. But this is last June. Now, since that time, there have been a couple of hearings held in which Nnamdi's lead counsel, Ifeanyi Ejiofor, and with assistance, has filed a motion to dismiss all of the charges based on the theory that they don't allege actual violations of criminal law. In fact, some of them allege no more than exercise of free speech and association. Let me give you just one example. One of the charges is that Nnamdi Kanu professed his adherence to the indigenous people of Biafra, IPOB. IPOB, about 4 years ago, September of 2017, uniquely in the whole world, was proscribed as a terrorist organization in an ex-parte proceeding. Ex-parte means IPOB was not given notice. The Attorney General went into court and said, President Buhari has told me that IPOB is a terrorist organization, and so you need to proscribe it. And that was the beginning and end of the case. Now, despite lobbying by the Nigerian government, well-funded, to have other countries list IPOB as a terrorist organization, it has uniformly failed. This is 173 other countries. And indeed, there have been 5 human rights experts from the Human Rights Council of the United Nations that sits in Geneva, who wrote a letter to President Buhari in late 2020, stating they had examined the case against IPOB and were very concerned that there was no due process, that Nigeria seemed to treat the mere search for an independent sovereignty through a referendum by peaceful means was a terrorist act. And these human rights experts said, no, that's protected freedom of association. And indeed, these 5 experts asked President Buhari, you need to reconsider whether IPOB is a terrorist organization because your process seemed to have violated norms of international law. They asked President Buhari within 60 days to provide what evidence and what process was utilized to demonstrate that IPOB was a proscribed terrorist organization. That's 60 days. Now that's over a year has elapsed since that request. And President Buhari, Nigeria, has come up with nothing, 0, to justify the listing. And mere membership in IPOB under the current Nigerian system is a crime. It's a terror.
Now we look at the national or domestic lawyer of Nnamdi Kanu, Chief Ozekhome, and what he has to do or say about this case.
Of Nigeria himself, Chief Mike Ozekhome, who is the lawyer to Nnamdi Kanu. Thank you so much, Senior Advocate, for joining us on the news tonight. We do appreciate your time. Just to start this conversation, you say you are appealing to the president to release Nnamdi Kanu through a more productive political solution. What exactly does that mean?
Yeah, what it means is that you may win the war without winning the peace. So at the end of the day, it is always better to have peace, lasting peace, not what Chief M.K. Abiola will call peace of the graveyard or peace of the cemetery. So I wrote to the president a 38-page letter with an executive summary of 3 pages, pleading with Mr. President to please release Nnamdi Kanu immediately and unconditionally, because Nnamdi Kanu's trial, as far as the facts have shown, and as far as I'm concerned as his lawyer, is nothing but a political trial. Nnamdi Kanu is only a metaphor for the Igbo struggle for self-determination. And self-determination is recognized as a right by several international instruments. The United Nations Charter, Section 1, United Nations Charter of 1945, Section 1 of the International Covenant on Political and Social Rights of the People, Section 1 of the International Covenant on Economic, Social and Cultural Rights of the People, Section 20 of the African Charter on Human and People's Rights. All of them recognize self-determination to determine your destiny, how you want to live, as a necessary concomitant of human beings as Homo sapiens. So that was how Nnamdi Kanu in 2012 founded IPOB, a non-violent organization. We all saw them marching on the streets of Umuahia, Aba, Onitsha, Enugu, and elsewhere, blowing whistle, marching, singing, wearing beret. They were not violent until the 14th of September 2017, when through Operation Python, the Nigerian army invaded the ancestral home of Nnamdi Kanu with his father in residence, Ozekhome Kanu, using Operation Python. In that operation, about 28 unarmed and innocent Nigerians were brutally mowed down. Nnamdi Kanu escaped through his teeth with the whiskers and landed first in Rome and then Israel, where he deposed to an affidavit to show the circumstances under which he had run away from Nigeria, that he did not jump bail which had been granted to him. Whilst on that bail in United Kingdom, as a citizen of UK, Nnamdi Kanu visited Kenya. And on the 26th of June, 2021, Nnamdi Kanu was forcibly abducted, like was done to Maru Diko on the 9th of July, 1984. He was kidnapped, forcibly abducted, blindfolded, tortured, and brutally, horrifically renditioned back to Nigeria, without Nigeria undergoing the due process of extradition law and going by the doctrine of specialty, which says you can only be brought back to face the trials on which you have been rendered, not existing counts, right, and not the existing counts on which you were being tried. So when Nnamdi Kanu was brought back, they had to again amend the 15-count charge, the 8-count charge that were against him before he was brutally brought back to Nigeria, to 50 counts. I went to court, argued against the counts as being not valid. The court struck out 8 of the 15 counts, remaining 7, over which we have appealed to the Court of Appeal. I have made this appeal to Mr. President because you notice that being the metaphor for the Igbo struggles, even though it's not physically outside prison, outside the gulag of SSS, where it's currently being kept under inhuman and degrading treatment, as found by the United Nations Working Group on Arbitrary Arrest in its report and ruling of 20th of July this year, the Igbos of the Southeast still obey him on any day his matter is coming up by sitting at home. This grinds to a halt businesses and the normal way of life. What I have done is to appeal to Mr. President to, to use extrajudicial means, not by force, but by calling upon the Attorney General to use Section 174 of the Constitution of the Federal Republic of Nigeria, 1999, as altered, as amended, to enter a nolle prosequi for Nnamdi Kanu. What does it mean?
If I may.
Well, this is from the leading counsel, the application and appeal he has made to the Nigerian president, which he never responded. But the judgment of the appeal court has been regarded as a disgrace to the government that has refused to take heed of the appeal. But the judges at the Court of Appeal has vindicated not only the counsel, the leading counsel, not only the international leading counsel, but also Mazi Nnamdi Kanu. That is the issue. The government does not want to listen. And as we continue, we will see what happened. As a result, Massive Human Rights and Freedom Initiative congratulates Mazi Nnamdi Kanu himself for his endurance, suffrage, and that God will help him to recover fully and become the normal citizen he was before he was pushed into the dungeon. We're also using the opportunity to congratulate the legal teams led by Honorable Mazi Mike Ozekhome San, Barrister Ifeanyi Ejiofor, Barrister Aloy Ejimako, U.S. Attorney Bruce Fenn, and all members of the legal team. At the same time, Massive congratulates the United Nations Committee Against Torture, Human Rights Council, and Lovers of Freedom, who intervened and they became a pressure group in this very abduction, kidnapping, and retention case, which is also a criminal case against the international community and Nigeria at large, and the people of Biafra and the indigenous people of Biafra, as well as the Igbos, as well as Nnamdi Kanu himself. Massive also congratulates and facilitates with the IPOB members worldwide and the Lovers of Freedom, the Biafrans, the indigenous people of Nigeria, Africans, and the world on this very great judgment. And finally, Massive Human Rights and Freedom Initiative congratulates also those who may have felt disappointed. With this, we come to the end of this very brief and congratulatory and facilitation broadcast. And we also will go into the area where the Attorney General of the Federation, Malami, is saying that they are going to discharge that Mazi Nnamdi Kanu is only acquitted but not discharged. That's another topic of the next program. However, we thank all our listeners, our well-wishers, and also we all together congratulate Mazi Nnamdi Kanu and the family and members of the indigenous people of Biafra, his legal teams, and lovers of freedom worldwide. We ask you to subscribe, share, push the notification bell, and also share our videos. Again, we plead with you to subscribe to these channels. It is educative channels, and it will help you understand some legal terms and what is happening on the issue of your rights and other things therein. With this, we come to the end of this broadcast. Thank you very much, and God bless you.